Good day everyone. My name is Maria Salsi Cairo, and for today's video we will discuss the marriage in the Family Code of the Philippines. Family Code of the Philippines, Executive Order number 209, approved on July 6, 1987. Let's talk about marriage laws. Marriage and family are social institutions protected by law. Article 2, Section 12 of the 1987 Philippine Constitution recognizes the sanctity of the family life and affirms the duty of the state to protect and strengthen the family as a basic autonomous social institution. Marriage is the foundation of the family. The family is the foundation of the society. The legal requisites provided by the Family Code of the Philippines are intended to ensure that those getting married possess the basic qualifications required of the married life. What governs marriage in the Philippines? Marriage in the Philippines are governed by state laws and the ecclesiastical laws. Filipinos planning to get married, therefore, they have to comply with the requirements set forth by the Family Code of the Philippines, whether such marriage is civil or religious in nature. The law of the Church focuses largely on the spiritual and psychological commitment brought to the marriage. A wedding always has the potential to become a marriage. The spouses must have the intention and the capacity to carry the marriage beyond the wedding date. Marriage in the Family Code of the Philippines. Marriage is a special contract of permanent union between a man and a woman entered into in accordance with the law for the establishment of conjugal and family life. According to Article 1, it is the foundation of the family and an inviolable social institution whose nature, consequences, and incidents are governed by law and not subject to stipulation except that marriage settlements may fix the property relations during the marriage within the limits provided by this code. It improves on the definition of marriage in Article 52 of the Old Civil Code of the Philippines by stating that number 1, marriage is a special contract. Number 2, it is a permanent union. Number 3, the union is between a man and a woman. Number 4, the union must be entered into in accordance with the law. Number 5, the purpose of marriage is the establishment of conjugal and family life. Let's talk about marriage as contract. How does the Family Code views contract? Article 1305 Civil Code of the Philippines stated that a contract is a meeting of the minds between two persons whereby one binds himself with respect to the other, to give something or to render some services. A contract binds both contracting parties and has the force of law between them. In what sense is marriage a special contract? Number 1, only a man and a woman can enter into marriage. Number 2, marriage is a permanent contract. It can only be dissolved by death or annulment. Number 3, in an ordinary contract, agreement has the force of law between the husband and the wife. In marriage, rights and duties are fixed by law and not subject to stipulation. Number 4, breach of contract gives rise to action for damages, while breach of obligation of husband or a wife does not give rise to such action, but laws prescribe penal and civil sanctions. What are the requisites of marriage according to the Family Code? Requisites of marriage under the Family Code. First, essential, legal capacity, consent of the contracting parties. Second, formal, authority of the solemnizing officers, marriage license, marriage ceremony. Essential requisites, legal capacity, must be male and female, must at least be 18 years of age. Contracting parties must be at least 18 years of age, male and female, and not under any impediment to marry. Impediments mentioned in Article 37, incestuous marriage, and Article 38, void marriages. According to Article 14, If the contracting parties are between the ages of 18 and 21, they must be present written consent to the marriage from their father, mother, or legal guardian. According to Article 15, while any contracting party between the age of 21 and 25, they must be present a written parental advice, that is a written indication that the parents are aware of the couple's intent to marry. Essential requisites: consent of the contracting parties. Consent freely given by the contracting parties before a solemnizing officer and in the presence of at least 2 witnesses of legal age. Formal requisites: authority of solemnizing officer. Who are authorized to solemnize marriage according to the family code? Any incumbent member of the judiciary within the court's jurisdiction. Any priest, rabbi, imam, or minister of any church or religious sect duly authorized by his church or religious sect and registered within the office of the civil registrar general. Any ship captain or airline chief only in cases of articulo mortis. Any military commander of a unit in the absence of a chaplain during military operation, cases involving in articulo mortis. Any consul general, consul, or vice-consul in marriages solemnized abroad. Mayors of cities and municipalities under the new local government code. Formal requisites: valid marriage license. A marriage license shall be issued by the local civil registrar where either contracting party resides. The application for the marriage license shall be posted for 10 consecutive days outside the office of the civil registrar. A license shall be valid in any part of the Philippines for a period of 120 days and shall be automatically cancelled at the end of the said period. No valid marriage license, no valid marriage. Formal requisites: marriage ceremony. Requires the appearance of the contracting parties before the solemnizing officer and their personal declaration that they take each other as husband and wife, in the presence of not less than 2 witnesses of legal age. The marriage should be solemnized publicly in the chambers of the judge or in an open court, in the church, chapel or temple, or in the office of the consul general, consul, or vice-consul, as the case may be, and not elsewhere. Absence and defects in essential and formal requisites. Article 4 of the Family Code of the Philippines states that the absence of any of the essential and formal requisites shall render to the marriage void from the very start, except as stated in Article 35. A defect in any of the essential requisites shall render the marriage voidable as provided in Article 45. An irregularity in the formal requisites shall not affect the validity of the marriage, but the party or parties responsible for the irregularity shall be civilly, criminally, and administratively liable. That's all. Thank you.